So the individual is arrested. Ideally, you should have them enter the program quickly. However, we don't want to force it upon them, and people do have due process rights. They do have the right to confront their accusers, so we don't want to violate any of their rights at all, even if we feel like, oh, they really need intervention. But priority is to protect their constitutional rights, first of all. So they will be arrested for a DWI. We will accept first offenders in our program, but just depending on the circumstances and their background. But it is meant for a second, third, and up as far as offenses for DWI. They would be arrested. They go through the trial process and then eventually plea or go to trial. You don't have to plead guilty if you're convicted at trial. You're still eligible for the program.
By the time a client pleads to a DWI or is convicted of a DWI, the program sentencing options have already been discussed with the client. So jail time, probation, regular probation, or a specialty program such as this, a specialty court. And the client has really made an informed decision about what might be best for them. Most people want to avoid straight jail time at all costs. They want to work very hard, and of course most people recognize that they have a drinking and driving problem and they want help. So we do discuss the option of jail time or the option of straight probation or this option, and they are heavily screened, which means someone from the program, one of the probation officers, comes and talks to them about that as well. I do discuss with them if they violate the program, if they pick up new charges, if they are convicted of another charge, they might face some jail time. Additionally, if they are terminated from the program, they will face jail time instead of probation. So we do spend a lot of time going over the reality, and the best case scenario is just a well-worked program without any jail sanctions. The clients do understand that it's going to be a lot of time. Sometimes they don't understand how much, and it's hard to explain exactly how much time any one person will spend in the program or how many sanctions a person will have, because it's sort of up to them at that point. But we do try and make it very clear what they'll be doing for the program, and it's a lot of time investment and energy investment and emotional investment in a program like this, but ultimately it leads to better outcomes than jail. I have a duty as the public defender working in this program to know it thoroughly and to have a written understanding and a verbal explanation for it, so I can give a quick synopsis, think about this program at an early stage, and then go through in more detail as we might get closer to putting someone in the program. And so I am refreshed on it. We have our workbooks, we have our program overview books that I keep with me, and then we also have weekly or bi-weekly meetings with the team to stay informed on the changes of the program and the requirements of the program and the resources the program can offer as well. So I certainly have a duty to just be knowledgeable about it as well, and then a lot of my job generally is just conveying a lot of information to people in a short amount of time, and so I try and keep it clear and concise, and certainly provide my contact information for people who have questions as well.
Our intake process includes like the first appointment that they see us, and when we meet with them, they are going to sign a phase contract that explains everything that they have to do in the first phase and how many points the first phase is. Then they're going to sign their conditions of supervision. So when they're with us, the sort of like what they have to follow in addition to the phase. We'll go over an ignition interlock contract with them and explain that we want the ignition interlock put on their car within a certain amount of time, and there's an entire packet for that. We will set them up with their color. We'll set them up with, so they can do urine test. We'll set them up with their groups and their treatment at the evolution group. We will set them up with Native American specific treatment if they desire that through First Nations. We'll do an intake screening for some of our grants that we have to do. And then we'll set them up with their first appointment to come to the Healing and Wellness Court and meet the judge and the rest of the team.
Like I said, I don't know, it's always like kind of nerve-wracking with just not knowing stuff, but I mean, as soon as you get in here, everybody does, you know, they answer all your questions and they try to help you feel comfortable about the program. So, you know, it's just, it was good.